Hi, this next unit is about persuasive writing, and this first segment in particular is how to organize a legal argument within a court brief. You'll recall that your objective analysis was organized according to the acronym CREAC, where you led with a conclusion and then followed with the rule in the explanation before you analyzed the facts of the situation in application and, if applicable, in counter-analysis. Importantly, those 5 elements remain important to persuasive writing, and all 5 are included in persuasive writing. However, these 5 components may move around, combine, or even shrink. It is possible to present a legal analysis in the organization dictated by CREAC, where you lead with the conclusion and then follow with the rule and explanation before talking about the client's argument and the facts of the client's case. However, this organization may not be ideal for persuasive writing. For example, the facts of the case may be critical to the legal argument, and they may be very persuasive for your particular client. But in a typical CREAC organization, the facts of the case are buried really at the end of the argument. So you might consider a different organization. While you would still lead with the conclusion, you might follow then directly with the client's argument and the facts of the case. And you would do this, for example, when the facts favor the client. You might then follow with a counter-argument if it's applicable, then the explanation, the description of the existing precedent, and then finally have the rule at the end. And I'll show you an example of what this looks like in a minute. As an alternative, you might start with a conclusion that's combined with the rule, and again, I'll show you an example of what that might look like, then move directly to the argument, the client's facts, have then a little bit of explanation, more argument, more explanation. You'll notice in this example that the explanation, remember that's your case descriptions, is a little bit smaller. And that's because in persuasive argument, you're allowed to describe cases parenthetically, whereas in objective writing, you are always describing those cases in the text of the analysis. Here, though, there might be occasion when it makes sense to describe a case only parenthetically. And again, I'll show you an example of what that looks like. Okay, let's look at an example of a legal argument that's organized 3 different ways. And the issue is this. The plaintiff has served a summons and a complaint to the defendant's teenage son. Unfortunately, because his mom suffered a heart attack shortly after he received the paper, the teenage son has forgotten to give the summons and the complaint to his father, the defendant. As a result, the plaintiff has asked for and received a default judgment against the defendant because the defendant never responded. This argument is one of several that the defendant is making, that the default judgment should be set aside based on the reasonable mistake of the son in not handing the papers over to his father. So let's take a look. Here you see the argument in the traditional CREAC organization. And you might want to pause here for a moment so that you can read through the argument in total. You'll see that the argument starts with the conclusion, as it should, that the default judgment should be set aside because it was an understandable mistake on behalf of the teenage boy. Next, you have the rule that courts consistently set aside judgments as a result of reasonable errors as opposed to willful neglect, followed predictably by the case descriptions. And here you have just 2 short case descriptions. That is then followed by the facts of this case, and of course an application of the rule to those facts. The problem here is that though this is a predictable organization, The facts of the case really favor the defendant, but they are coming at the end of the argument. And by then, the judge has had to wade through quite a bit of other information before finally getting to the heart of the argument, which is in this case, the facts. So you have options. In this first alternative organization, note you again lead with the conclusion, always going to be the case, but you move up the facts of the case so that they are better highlighted to the reader, who in this case is the court. You have in the yellow an embedded counter-analysis and rebuttal, followed by those case descriptions. The explanation or the case descriptions still need to be part of your argument. They are the piece that supports your argument, but they can come later after the factual description. And in this example, the rule, because it's fairly simple and straightforward, is all the way at the end, although the writer has skillfully linked the rule back to the very beginning and to the conclusion. Here's another organization that you might consider. It again starts with the conclusion that the default judgment be set aside, but then it alternates facts, rule, a little bit of case description, more facts, more case description. Again, remember those case description is supporting the argument made just previously, and ends with even more facts and a counter-analysis and rebuttal. The advantage of this organization is that you see for the first time that the case descriptions are presented parenthetically. And that's possible here because these case descriptions are relatively straightforward and can be succinctly stated in a single phrase within the parenthetical. The advantage here is that the reader, the court, is focused mostly on the facts of the case, and the supporting case law, the existing precedent, is tucked into kind of that supportive lesser position, keeping the focus always on the facts. Again, that's possible here because the cases are relatively straightforward and they're not particularly similar on the facts, so they don't need that emphasis of a full textual description. So this is yet another alternative that's possible in your organization. Regardless of which organization you use for each of your legal arguments, there are some points to keep in mind. First, you don't want to start a legal argument with a topic sentence with, for example, the next issue is whether the mistake was reasonable. That's a waste of space. That sentence isn't telling your reader enough information. Consider the alternative. Lastly, the default judgment should be set aside. That blue text reminds the court of what the client is asking for. Because Gregory Dunn's mistake was understandable, the red text provides the because to the judge. A much more effective and interesting start to your legal argument. Next, you need to consider where the rule belongs. If the rule is complex, if it's open to debate, you probably need that rule to appear very early in your argument. If it's common, if it's simple, for example, it can wait, as you saw in the previous example. In any case, however, don't hide your rule in a parenthetical. The rule is far too important. It deserves textual space, and it deserves that emphasis so that the court can readily identify the rule that governs the legal issue that you are analyzing and arguing. The rule can sometimes be combined with your conclusion right up front. For example, this sentence, the default judgment should be set aside because it was a result of Dunn's reasonable mistake and not his willful neglect. The rule is in that last part of the sentence, reasonable mistake okay, willful neglect not okay. If you're going to go with this organization, and it's a great space saver to do this, you must provide citation at the end of that sentence. The citation lets the reader know that this sentence is doing double duty, that this sentence is both a conclusion and contains the applicable rule. Again, this is probably only available to you as an option when the rule is pretty succinct and straightforward. Next, you have to be thoughtful about your case descriptions. If the case is important, it deserves a textual space description and not just a parenthetical. And a case might be important for a variety of reasons. If the facts of the existing precedent and the facts of the client's case are similar, and you want the results to be the same, the results in your case to be the same as the results in the precedential case, then that case might deserve a textual description. You want to bring emphasis to that case. Alternatively, if the case establishes the rule, if it has high precedential value, for example, it's a Supreme Court case, that might also dictate that you describe that case textually. Also, if the case is complicated, if you need more than a single phrase to describe the case, then you're stuck with describing it textually, even if it's not a critical case. It simply is dictated by the necessity of needing a little bit more space. Note that you can describe some cases textually while you describe other cases merely in parentheticals. Completely acceptable. However, be thoughtful about your parentheticals. Don't use more than 3 parentheticals in a row. They're hard on the eye, and what will happen is the court will read the first 2 parentheticals, possibly the third if they're short enough, but is surely going to skip anything after that. So you need to be careful in your use of parentheticals. Counterarguments. It's very critical that just because we're in persuasive writing now, you don't simply ignore the counterarguments on the other side. It's also critical, though, that you don't quite tee them up clearly and succinctly for the other side either. Therefore, in a brief, you should never have a sentence that begins, "Plaintiff may argue that," or "Plaintiff has argued that," or "Defendant may argue that." That is handing the other side their argument on a silver platter, a little too clearly for the court. So you have to be more subtle and sophisticated in recognizing textually counterarguments and also providing that rebuttal. For example, in the example just given, you might surmise that the plaintiff is going to argue that because Gregory Dunn was 17 years old, he should have understood the importance of the legal papers and gotten them to his father. You want to deflect that argument, but do it in a subtle way. And this sentence does that job for you. Gregory Dunn was stunned by his mother's heart attack. Even a responsible 17-year-old child, note the use of the word child, can understandably forget important legal documents. You've therefore rebutted the argument that Gregory Dunn at 17 should have been more responsible by surrounding that argument with more favorable facts, that is, reminding the court that his mother had just suffered a heart attack. Therefore, you haven't ignored the argument, but you've addressed it pretty subtly. Note that if you have multiple legal arguments in a brief, the organization of one legal argument may differ from the organization of the other. And that's because if the legal argument contains facts that are favorable for you and for the client, I should say, then you should work hard to get those facts near the front of your argument. But there might be an alternative or a second argument in which the law favors the client. And in that case, you want to emphasize the law by moving that forward. So organization can vary from argument to argument. Most importantly, if you stick strictly to the CREAC format and organization because it's what you have comfort with, you're very likely missing the valuable persuasive power of organization. That's because the beginning of each section of your brief, and frankly each paragraph of your brief, and even each sentence of your brief gets your reader's best attention. So use that to your advantage by being thoughtful about the organization of your argument and lead with what favors the client. That same principle will apply to the organization of your introduction and the organization of your facts section which are the subjects of the next two segments.